morning, everyone. Welcome to the panel on wrap contracts. My name is Leonora Ledwon, and I'm a professor here at St. Thomas. And I'm very excited about this panel. This panel is really going to feature a very hot topic, and we're focusing on Nancy Kim's new book, Wrap Contracts, Foundations and Ramifications, out from Oxford Press. And we have the author here, we have Nancy Kim, and we have three panelists who are going to respond to particular issues in her book, and then we hope we're going to get some good Q&A going here as well. Unfortunately, we don't have Keith here or Miriam. Miriam had a health issue, and Keith just moments ago had to leave for the death of a family friend. So we're going to continue with our panel here, and they're all great troopers, and they're also expecting good questions from you, so we want some good participation. We're going to start with Wayne Barnes, and let me just give you a little biographical information on him. He's been a member of the faculty of Texas A&M University School of Law, formerly Texas Wesleyan, since 2003. He teaches contracts, secured transactions, bankruptcy, and Texas consumer law. His scholarship has primarily focused on contract law, including the implications of contract theory for ascertaining assent by consumers to standard form contracts. That's a great topic for today, both in the offline and the online context. Professor Barnes holds a JD from Texas Tech University School of Law, where he also served as editor-in-chief for the Texas Tech Law Review. And I see that we have some students here today from St. Thomas, so it's always good to hear students who have done well, gone on to become professors. And he also earned his BBA in finance from the University of North Texas.
Well, good morning. Thanks for coming. I was very honored to be asked to be on this panel. I was honored that Nancy, cited one of my articles. I think it's the first time anyone other than a family member has actually read one. This is a really interesting topic, and for those of you, maybe everyone in here has already read the book, but it's a really wonderful, timely book. I just thought I would talk just briefly about what she kind of does in the book, extremely briefly. I'm sure I won't even touch on near everything, but just briefly to kind of sort of frame what I was going to say. Nancy has this tremendously terrific background of the development of sort of wrap contracts in context, and of course we mean browse wrap, where you go to a website and you don't even have to, and this is kind of reverse order historically. I suppose the shrink wrap developed first. You open the box of software, you rip the packaging off, and lo and behold, there's terms inside. So we took to calling that shrink wrap. I don't know, Juliet, were you first at that, or that had happened before you? Then they started using click wrap. We all know this, terms. If you want to proceed, you want to install the software, you want to download the thing, you must click here. There's terms if you want to read it. We all read it carefully, right? As an aside, I joke with this very condescendingly in my contracts class about how you all read the form language of contracts, and I know this is a truism, everyone knows it's true, but I don't do it either. We're doing some remodeling in our house right now. We did a home equity loan to kind of help pay for it, and I didn't even spend, I don't think, 3 seconds looking at the language of all the documents I sent, and that was in the real offline world, Nancy, let alone online. But nevertheless, we have these click wrap and then browse wrap where you don't even have to click on anything. And the courts, as Juliet and others have, Nancy and others have documented, the courts have taken to, with some caveats, have taken to upholding the assent to those in a traditional contract basis. So the click has essentially replaced the signature. Right, and so I'll have more to say about that in a little bit. But Nancy goes through, and the book is extremely engaging. She talks about the development, she talks about a lot of the practices, and she gives this kind of marvelously amusing parade of horribles in her example towards the end of I don't know if it's not a day in the life, it's a week or two in the life of this person who is more and more disadvantaged by all these online form contracts she has signed, and it really highlights the problem. And what she does at the end of the book is, after she's gone through all of this history, is, to me anyway, and maybe there's more to it, I'm sure there is, but to me the big thing that jumped out at me is Nancy's big, probably biggest number one beef is that in this context it's kind of gotten out of hand, right? And so contracts, people don't even know they're doing contracts, right? When they're clicking, yes, just give me past the thing so I can download Flappy Bird or whatever it is. They may or may not even thinking about the fact it's a contract. It's something they got to click to get to whatever it is they want to do. And lo and behold, later when they find out that they've entered into a contract, then it's dreadfully disappointing for them, and it's a huge surprise. And we have this problem that they don't even know they're entering into contract. So she gets to her final chapter and lays out several really sensible prescriptions for a way to sort of right the ship. And I apologize, I'm PowerPointless, but basically they are, number one, we should impose a duty on the merchants to draft more reasonably, right? And I take it to mean this is largely notice-oriented. And so consumers have a duty to read, so they should have a corresponding duty to draft reasonably if we're going to have this duty to read. And that includes not only less legalese, but more effort to make the terms noticeable. Let's make the I accept button say, click here to agree to the contract, right, of Facebook. Let's give more color, let's give more text bubbles, etc. Let's make it to where it's more clear that the consumers are entering into a deal. She also wants more tailored assent, maybe specific assent to certain types of provisions. She uses the definitions of shield, sword, and crook, right? So shield provisions is Nancy's term for terms that limit liability. They go with the service or product that's being offered, so limitation of warranties, for example. Her definition of sword provisions are, taking the consumer's rights away, right? Say maybe subjecting them to arbitration, taking away their right to a jury trial. And then the most egregious, the crook provisions, Nancy uses that term for terms that, and these are really in vogue now, especially with social media, terms that appropriate benefits that aren't related to the transaction. So LinkedIn, or certainly Facebook, wants you to, buried in the print somewhere, is they want to be able to use your mug, right, your face, on ads that other Facebook users will see, right? I'm not as familiar with how LinkedIn does this, but I know it's gotten some publicity with Facebook. And so they just want a perpetual irrevocable license is usually the language for that. And so Nancy kind of calls those the crook provisions, and I'm sure there's other examples. Has nothing to do with it. It's just kind of a grab, right? While we're at it, as long as we can put as much fine print in this click wrap, as we have terabytes of storage, then we might as well just get all things we can get. And that's one of the concerns Nancy mentions, is that untethered from paper restrictions, you get a Hertz rent-a-car, and there's a limit. They can't do this, right? The contract that's this tall, but there's really nothing stopping them from doing the click wrap, right? It's just a matter of how long the scroll bar goes down, right? And so it would be interesting empirically to see. Nancy's quite right. There is no limit. I'd wondered about word count. I guess we could do what is the comparison in the online versus offline context. But so she prescribes a duty to draft reasonably. She wants more tailored assent, specific assent to these crook provisions. And she talks about, thirdly, revitalizing existing doctrine, maybe dusting off. And I've perked up on this because I've argued about this before. The doctrine of reasonable expectations in the insurance context maybe has a new place here that we could argue for, and that's also as somewhat codified in Restatement 211. I'll talk about that in a minute. And then she also has a really bold proposal for modifying the unconscionability doctrine and just pretty much completely reformulating it and making sort of coercive terms presumptively unconscionable. And if I have time, I'll talk about that. Otherwise, we may talk about that in the Q&A. So I had to think of something to say other than Yay, Nancy, you go, girl, right? So I pretty much largely agree that all of her suggestions are very sensible and would increase the protection to consumers. But I thought I would just mention a couple, handful of things that jumped out to me as things I was just thinking about. And these aren't really necessarily, these aren't even contesting. They're more I would characterize as corroborating observations. And so as I was looking at it, I kind of, and I don't know if I'm forcing this overlay, but I kind of thought in terms of procedural, mechanical, logistical assent concerns. So kind of borrowing from the traditional elements of unconscionability, there's procedural and there's substantive. So I wanted to talk first about just the procedural assent concerns, and then we'll talk about substantive. Are there certain terms that we just substantively don't like regardless of the quality of the assent? So the procedural assent is about, really Nancy says at the outset, as I mentioned earlier, do the consumers even know they're entering into a contract? You know, that's at least not the problem at T-Mobile or at Hertz Rent-A-Car, right? They're given the piece of paper, they go through the ceremony, still in some places of physically signing. And so they kind of know, you don't use your signature very often these days, and so they kind of know they're signing a contract. It's in the offline world. And I think one of Nancy's biggest concerns, and I really agree with it, is in this online context, how do we make sure and at least rise the online contracting environment to where they at least know that's happening, right? And maybe I'm a decade late on this, but I've always agreed, you know, the clicking as the signaling functions I know Juliet's talked about, as really lacking. You know, the signature, when do you write your signature? Well, not too terribly often unless you're signing a contract. Maybe you still write letters in longhand, I don't know, forms, HR forms or something. You know, we click. My gosh, I probably click, I don't know, sometimes 100 times a minute or something. I mean, I click to change fonts. I click to, launch the Angry Bird. I click to print, right? And I click to actually enter into a contractually binding agreement, right? I sometimes, you know, I don't know about you, I still use a mouse and I click so much that sometimes I have this muscle memory and I have to take my hand off or I'll inadvertently click sometimes. And so clicking, I mean, again, I'm a decade late. Maybe that ship has sailed. Maybe it's irreversible, but I've always not liked clicking as the assent. And one of the things I thought about as I was reading Nancy's book, and she mentions this in her chapter on assent, is maybe we could have more specific assent, maybe more clicking for every single term that Facebook wants to impose. Or she mentions, and this is what really perked my interest, maybe we could go back to the old school physical signature. And she mentions facsimile signature program where you can actually get a PDF and physically sign it and scan it and upload it. And what I was thinking too with increasing technology, you know, I get a cab these days and I want to pay with a credit card. They whip out their iPhone and I, you know, sign right on it. You know, that's been the case a lot of times with the point of sale systems in stores. You know, we have the technology to where we you know, and when the click wrap cases first developed, it was in the days of, you know, Netscape and Windows 95, and so we didn't necessarily have that. But now, I wonder with the increasing technology if we couldn't get away from the click and more to the physical signature, whether on a touch screen or a tablet, et cetera. And so I think that would be a welcome development, how we get from here to there. You know, the courts, I suppose, would just have to be encouraged to start saying, well, now that you can do this, are we really going to still use the click? So I like that idea, and I think that coheres with what Nancy said. So physical signatures rather than clicks. The other thing, and I don't know where this fits, but I really like something else Nancy said in the book in talking about browser app, and I don't even know if she meant it to be a big part of her proposal, her analysis, but in talking about browser app, you know, you don't have to click anything. There's a link at the bottom of the website and terms and conditions. You know, basically the courts have said in a lot of cases, hey, you enter this website subject to those terms and conditions, right? And a lot of times the courts have held that enforceable even if you don't have to actually ever affirmatively click. And Nancy mentioned something that I thought was really cool, and that is that maybe we should shift on that to sort of a notice and a license analysis. And I have seen in some of the stuff I've done and others, or Concur and others, who have talked about the online environment as this virtual environment, right? So you go to target.com, and in a sense, we say you're in virtual world online, right? You're going to a virtual Blackacre, right? If I went to a real Blackacre, the owner of Blackacre can condition my entry to it. And if I violate that, then I've exceeded the scope of the consent. And so I like that a lot. And I think one of your points was the difference between notice and affirmative consent. And maybe there's limits on what we can impose, maybe more in the shield range and obviously less in the crook range. But I liked that a lot, and I wanted to think some more about that. But shifting our thinking toward that's not even contract so much as license for entry, much akin to the offline property world. So those are a couple things, just, observations. I tried desperately to thread these together to make sense, but basically they have to do with this procedural assent. The one thing I will say, and I guess it's obvious, and I don't know that Nancy would disagree, is I think even if we, as far as this procedural assent concerned, I think the best we can do on that vein, talking about the substantive in a minute, but I think the best we can do is get it to where it's like the Hertz rent-a-car situation. To where at least they know they're entering into a contract. At least you're incurring a binding obligation. But even once we get there, of course, we do, the sad part of the story is that we do still have all the problems with standard form contracts, right? They're not going to read them anyway, right? They're much less likely to read them. No one reads them. Nancy has this wonderful example of the study where they were supposed to be watching people on the basketball court, and then there's some guy in a gorilla suit, and amazing how if their attention was focused elsewhere, they wouldn't see it. Other examples, and I forget, I remembered them anecdotally, some of these more modern contractors, online merchants, have done some kind of fun things, sort of highlighting the problem, even though they want you to be bound anyway. Like, I don't know if you heard this one, someone put for a while that by clicking you agree to sell your soul, right? And no one noticed it, or maybe one. Someone else put in one of their terms of service, hey, anyone that reads this paragraph 347, if they'll notify us at this particular email address or whatever, can have $1,000. And I mean, did anyone claim it? Maybe one or two. And so all that does is highlight what we've known for forever, right? No one reads these anyway. So even if we can get the procedural assent fixed and make it clear that people know they're in contracts, we still, of course, have the age-old form contract problem. No one reads them. Bargaining power as a concept got attacked a little bit yesterday, but I mean, we still have that problem. They're adhesive in nature. And of course, all the other problems, even if they did read them, we know, as Russell Korobkin and others have said, that there's all of the cognitive and decisional biases, right, that are problems. Even if they read everything and they could understand it, by the way, literacy is a different issue altogether. But even if they read them and understood them, and they read the arbitration clause or they read the perpetual irrevocable license, would they care, right? Well, I don't think that'll be a big deal, right? That's in the future. I don't think that'll happen to me. I don't think I'll ever litigate with them. And we humans have all of these cognitive and decisional biases and problems in assessing risk. And all those issues, of course, are still going to be present, even if we really drum it through consumers' heads that they're, yes, you are entering into a contract when you go to, Zappo.com. So that's procedural assent. I think we can do, and maybe that's all we can do. We can raise the level of the quality of the procedural assent so that at least they know they're entering into a contract. And then we'll still go on with the debate about what do we do with this thing we've come to call a standard form contract. Leonora, I don't know where we are in time. We're kind of sort of, oh, geez, okay. Yeah, no. I'll just say one other thing. I can do it pretty quick. On the substantive assent issue, and broadly speaking, that's okay. Are there any terms these days that websites or online merchants are asking for that are kind of less like a warranty disclaimer and more like, selling a kidney, right? Just not desirable as a matter of public policy, and is that a problem in any type of terms? And the one thing that Nancy talked about that really also set me to thinking was she mentioned and this is true to my heart, dusting off the doctrine of reasonable expectations, or Restatement 211.3. In Restatement 211.3, of course, it's part of the provision in the second restatement on standardized form terms, and it says that where essentially the merchant has reason to know that the person assenting, the consumer clicking in our case, would not assent at all if he knew that the writing contained a particular term, then that term's out, right? It's not in the contract. And that would be great if only any courts had followed it, right? I suggested this a while back, and as we all know, that fundamentally transformed the jurisprudence. No, right? It got ignored. I don't even think Nancy cited that one. I argued before that this makes sense in terms of objective theory, and I'll have to close with this, but objective theory the duty to read has traditionally said, if you sign, a reasonable person in the position of the merchant should take that to mean you agreed to the whole deal, right? You blanket assent. So Robert Rocker said you're kind of putting your you're putting your head in the mouth of a lion. You sort of hope it's a friendly lion, right? That's what we take it to mean. It could have gone the other way. We could have said, now merchant, you know full well the consumer hasn't read all this. So it's preposterous to say a reasonable person in your position agrees to all this, especially the ones you know that if they actually came to mind presently, they might have a problem with. So I've argued that before, and I would welcome the development of that. It has had some particular play in insurance cases, and not too much else. Maybe there's something special about wrap contracts where you could argue, well, because of the particularities involved, we should argue for that implementation. One last thing. I really wondered, the problem with 211 is you have to prove if the merchant only, or if the consumer only knew this was in here, it would be a deal killer, right? They wouldn't agree to it. And so then you have to prove, okay, let me explain to you arbitration, or let me explain to you this perpetual irrevocable license. Now, are you sure you want this Facebook account? Because, if there's a dispute later, how many of them would really go, gee whiz, I'm glad you told me. I can do without this Facebook deal, right? I can do without this iTunes account. And so I'm just sort of skeptical. I wish that everyone was as outraged as we are, but I kind of am skeptical about that. And, even when I started writing in this area 10 years ago, there was this quote I used where, the average member of the populace, if there were free Big Macs, if you just gave up a little bit of DNA, right, the line would form around the block, right? And so I have this concern that everyone's as outraged about all these sorts of issues as we are, but maybe that's a different story. Well, I need to stop. I'm sure I went over, but I have a couple other things. I'm sure we're going to have a good, robust Q&A over it, but I guess that's my thoughts. Wonderful book. I think, it's a very important step in engaging these issues, and I'm sure it's going to generate a lot of healthy debate and scholarship to come.
Next we're going to hear from Dan Barnhizer, the Bradford Stone Faculty Scholar at Michigan State University College of Law, where he teaches and writes on issues relating to contract theory, and the rule of law.
But clearly not PowerPoint, because I don't get this anymore. Okay. Well, first off, I'd like to thank Jennifer and St. Thomas and the Law Review and the presenters throughout the conference. I was told a few people, this is the only conference that I have to go to. The AALS for me is if you want to read my article on scam blogs and how AALS resembles the fall of the French monarchy, then I'll send you a reprint. We've got the gala ball and let them eat cake and everything, but that's not the book. I love this conference. The presenters, the people that come to this. There is no other conference like this that goes year after year, and so thank you for carrying it on and you've done an amazing job today. So I appreciate that. And I learned my lesson yesterday, so I'm going to get to my conclusion first. Nancy's book is great. Read it if you haven't already. I'm going to go through some critiques, but what I'm on her sword, shield, and crook provisions. But what I'm going to conclude with is I think that this taxonomy is extremely useful, and I want to lead with that. It's useful as part of the way that we can re-educate. Sorry. It's useful in re-educating the courts. Right now what we have, thank you very much, is a situation in which the courts are captured. And I tend to be sympathetic to this. The courts are captured in a neo-formalist paradigm in which they see it as any inroads against strict enforcement of the contract. Reasonable expectations doctrine. It is anathema to the accepted orthodoxy of pacta sunt servanda in the new millennium. We can't reinterpret terms. 211 sub 3 is how dare you suggest that we follow the restatement? What do they know? So this taxonomy breaks out of the traditional textualist versus reasonable expectations versus contextualist paradigms, and it helps us move the judges into a position where they can actually see that there are problematic terms. What I'm going to do now, after I've said all that, is go through, because I think that the terminology is hard for me, and it's hard for me to grasp intuitively, because and Nancy makes this clear in the book. I mean, this is a actual disagreement where she sets up a Hofeldian, or takes the Hofeldian taxonomy and kind of collapses it. And for me, that just made it. It took me a while to realize just how powerful these provisions are, or this terminology can be. So I'm going to start with some slides on get at what I think is the basic problem that Nancy is trying to illustrate with these three terms: the sword or shield terms, sword terms, and crook terms. So the first one is a story that just came out. My research assistant sent this to me last week. It's a card the headline: "Relax card holders, Capital One won't be knocking on your door." And this is something that fits well with Wayne's social media piece from 2012. Because Capital One, all they were doing, this appears to have been perfectly innocent, in their normal Capital One contracts for loans for a car, for a hovercraft, for a motorcycle, for a boat. They include a provision that refers to repossession rights and rights to come and attempt to collect personally at your door. If you take out a loan on your car, I used to work for a car dealer. I helped with one repo. It was exciting. I didn't actually get to go to the repo. I got to sit in the office and wait. So it wasn't as exciting as it could have been. But the idea with those is that it's a normal contractual provision, and all that Capital One did is take that standard provision and also just happened to include it in their credit card agreements. I tend to suspect that was probably just innocent error. They probably weren't thinking of that, but the social media picked up on the fact that all of a sudden Capital One not only knows what's in your wallet, they now know what's in your house, because they're going to come to it and take your stuff. And I think this is, if the actual terms of this contract, I think this would fit, if it were actually enforced, would probably fit within the sword terminology. The Capital One has entered into a contract, and they are going to come out and create a right in themselves to take something from the consumer that the consumer ordinarily wouldn't have. The consumer ordinarily has a property right, may exclude people from their property. Now Capital One has gone out and taken that property right for their own use. Second is, as you all may remember from the listserv in late November, early December, the story about cleargear.com. For those of you who haven't read it, Cleargear in 2008, John Palmer, who is married to Jen Palmer, John Palmer entered into a contract for, as far as I can figure it, it was the sale of a couple $100s worth of T-shirts and stuff for Christmas gifts or something like that. And they ordered in November of 2008. By January of 2009, the stuff still wasn't there. PayPal automatically canceled the contract. So from the Palmer's position, they had called several times, no answer, and so therefore they thought the contract was done. 2 years later, Cleargear updated its rolling contract terms and included a standard term that I think I have it here, includes a standard terms, where'd it go? Here we go. A standard non-disparagement clause. Your acceptance of this sales contract prohibits you from taking any action that negatively impacts Cleargear.com. It's like in terms of the world of customer service, they win. The award for biggest fail ever. The Palmers say this clause was added after they purchased the terms, and it was added in 2010, and Cleargear tried to enforce this clause against them, including a $3,500 liquidated damages provision. I turned this into an awesome final exam question, so if you all want that, just email me. This one, it looks, if a crook provision makes sense, then it has to be this non-disparagement clause, but as I'll talk a little bit later, I think that it may actually fit best with the SHIELD terminology. And so what I'm trying to do through this project is figure out how to better define, pick individual clauses and say this must be a crook clause. And Your Honor, this is why it's a crook clause. This is what the factors are that suggest you have to not enforce this. The last clause I'm going to talk about is the Gamestation Contract that Wayne alluded to. I have proof that I actually thought of it before he mentioned it. But the 7,500 online shoppers who accidentally sold their souls on April 1st in a prank. The clause, they had notice of it, the clause, and a few people did object to it. By placing an order via this website, 12% of consumers saw this. On the first day of the fourth month of the year, whatever, you agree to transfer to us a non-transferable option to claim for now and forevermore your immortal soul. And there's surrender and delivery provisions. If it's a good UCC Article 2 contract. I'm not sure if it complies with 2-105 though. So it depends on whether you're a physicalist or a mind-body dualist. So 12% purchasers noticed the ruse, which I wish Amy Schmitz was here, because her work on actual consumer protection or consumers seeing these types of clauses and actually reading and responding and after the fact negotiating for better deals is some of the most important stuff out there today in this field, I think. So going into Nancy's, how much time do I actually get? I'm just kind of winging this.
If you follow my rules.
You have like 2 more minutes.
2? Okay. Okay. All right, so that's the end. The SHIELD provisions, I've got the definition up here. The drafter of the form contract uses the contract as a shield to protect itself from claims by the other party and to contain or limit the responsibility it would have for the product or service it introduces to the marketplace. And the examples are disclaimers of implied warranties, non-commercial use restrictions in software licenses, and limitations of remedies. These are situations where the producer is not willing to give an implied warranty of merchantability. I'm protecting myself against the uncertainty of that implied warranty. And so they use that term as a shield against that unexpected liability. These terms can also be swords. Contract provisions which serve a sword function, destroy the other party's rights or entitlements that are independent of or unrelated to the use of the product. So this is where a warranty relates directly to the car. That's what it's a salient, and I think that might be one of the touchstones is the salience of the term to the consumer, from the consumer perspective. If the warranty relates directly to the product being sold, that's one thing. But if we're talking about something that is dealing with managing the party's relationship after the delivery of the goods, after the transfer of title has occurred, after the services have been performed, then that's where the sword provisions seem to kick in. About 8 more minutes?
There's a negotiation going on.
I love this. I love this group. Okay, so I can do 8. The typical list, and I'm breaking this out, so the sword and the shield and the crook provisions, in talking about sword and shield, trying to decide what makes it a sword and what makes it a shield is actually kind of problematic. So I've got my list of what the literature seems to focus on are contract scholar fetishes for the problematic clauses. These arbitration clauses, class action waivers, forum selection clauses, choice of law, and so on. And trying to pull those out, because this is where I start getting into the Hofeldian analysis. Where Hofeld would, the sword and the shield, the paradigm examples of it are the difference between promissory estoppel and equitable estoppel. So promissory estoppel creates a right in the promisee. The right is a claim, a legal claim for damages or for enforcement against the other party to the promissory estoppel transaction. The other party is under a correlative duty. Those always have to exist together. That's distinct from the equitable estoppel rules, which are a privilege no right relationship. When you make a representation upon which another person reasonably and detrimentally relies, that other person has a privilege to rely upon that representation, and the representer, have no claim against them, no legal right to impose an inconsistent legal relationship on them. And just looking through this list of Hofeldian jural relationships, I'm trying to figure out if the sword, shield, and crook taxonomy fits well with that relationship, because I'm trying to figure out what each of these problematic terms does that makes it a sword, a shield, or more importantly, the crook provision. And I think, and Nancy did not intentionally, in the book, she intentionally does not put it into the Hofeldian analysis. When I do so, just in terms of trying to organize it in my head, you can't really tell. The sword provisions or the shield provisions seem to be spread. I just have a few examples up on the screen. Liability waiver clauses are either a privilege no right relationship or an immunity or disability relationship. Arbitration clauses are a right-duty relationship. It is a promise to I have a right to force you into arbitration for any disputes. The class action waiver, also likely immunity disability. And so I'm not sure that the function in Hofeldian terms of these clauses or the classification fits well with the taxonomy that Nancy puts out in the book. But the important part is the crook provision. So I like the taxonomy for distinguishing between sword and shield, which, as the book makes clear, is there may be good reasons for this. But there's these crook provisions for which there are no good reasons. And the metaphor of the crook, as the book notes, the metaphor of crook is used to describe a company's stealthy appropriation via a non-negotiated agreement of benefits ancillary or unrelated to the consideration that is the subject of the transaction. That is the gamekeeper's example, the immortal soul provision. That's a perfect example of the crook provision, where 88% of consumers signed that without knowing, clicked I accept without even knowing that, by the way, here's my bag of oranges and my soul also on top of that. So I like this metaphor. The things I want to tease out a little bit in my remaining minute is that the metaphor of crook only works from the consumer's perspective. The Facebook, Mark Zuckerberg doesn't sit back there thinking, I'm a crook. Mark Zuckerberg thinks the world of himself. This is going up on YouTube, isn't it? Mark Zuckerberg can see me now. So Facebook, from Facebook.com's perspective, Facebook is not about providing cool, weird ways to like 15,000 people Facebook.com is a data collection, collating, organizing, and distributing business. They are in the business of taking your data, collating it, organizing it, and selling it to someone else for profit. From the company's perspective, the cute little website that with its likes and its games and and the face tweets and everything, that's the price that the company has to pay in exchange for all of that juicy consumer data. And moreover, the consumer knows this, and they don't know what's going to be done with their data. Nancy in a 2010 conference gave a fantastic example of Facebook, under its privacy terms, can take a woman from we talked about this on email, a woman who's a Christian counselor at a camp, and put her up on her picture on meetlonelysingles.com, because they own everything she puts up there. So it may not be individual breaches or individual actions may piss off the users, but in general, in abstract, the users do know that their data is going to be stolen, or taken or used and sold to others. So what is the benefit of this? I think, as I said at the beginning, that courts have gotten used. They have gotten into the habit of looking at these online terms as if they were real contracts, because that's the only language we have. I travel a lot in the former Soviet countries and Soviet-dominated countries in Eastern Europe, and many of my friends talk about doublethink. The idea of our brains the ones we're allowed to speak in the real world get locked into these channels of this is what is permitted speak within our political reality. And in the back, we know that there might be some problem that might not be real. It might be unjust, but we dare never say that. It's almost like courts have gotten into that same mentality of, we know that contract is a neo-formalist paradigm. We know we have to strictly interpret the text. We are back in a textualist paradigm, but in the back of their heads, they know that there's something out there that's just not quite right. And that something that's out there that's just not quite right are these crook provisions. And it's the identifying them and being able to communicate that rhetorically to the court that I think is just an absolutely powerful contribution. So I'll leave it with that.
Our next speaker is Jim Gibson. Jim is a professor of law at the University of Richmond and is the founder and director of Law School's Intellectual Property Institute. He teaches rights and consults in the areas of intellectual property, contracts, and law and technology. His scholarship has appeared in the Yale Law Journal, Virginia Law Review, UCLA Law Review, and elsewhere. He has been a visiting professor at the University of Virginia, and he's a recipient of the University of Richmond's 2007 Distinguished Educator Award. His latest article, Vertical Boilerplate, which is a great article, Vertical Boilerplate, shows that the average computer purchase binds the purchaser to 25 contracts, totaling almost 75,000 words.
I'll try to keep my comments shorter than 75,000 words. So thanks to everybody. Thanks to Nancy for writing such a great book and including me on the panel, and Jennifer and Leonora and everyone for including me. I've really only just begun to do any work in the field of contracts, and so for that reason, of the many, many things to like about Nancy's book, I liked how effortlessly comprehensive it was. I don't know, maybe effortlessly is the wrong way. It appears effortless. I'm sure you would tell me it took quite a bit of effort, but comprehensive, I think, definitely fits. It's because I came to this topic from the world of intellectual property, where I'd written on licensing and private ordering in that world, and we IP scholars try to work really hard on getting those entitlements right, and then we discovered that all of you contracts lawyers just do different things with them once they actually get out there into the marketplace, and the entitlements that we're balancing are very rarely the entitlements with which consumers actually interact. And this is, of course, one of the many topics that Nancy talks about in her books as a consequence of wrap contracts. And so once I started to move over into the world of contracts and try to figure out that, I was just immediately bewildered by the sheer tonnage of problems and the different ways one could characterize and attack the problem. And one of the things that Nancy's book is so good at is just sort of breaking that down in a really understandable, comprehensible way, explaining the different angles on it and critiquing them. it's just a great service to sort of the novice contract scholar. I'm sure it's a great service to the experienced contract scholars as well and to the general public, but it was just really helpful for someone in my position. So now I'm going to move to the part of the talk where I pretend to be reviewing Nancy's book, but really just talk about what I want to talk about, which is the time-honored law professor tradition when you're asked to do a book review. So I want to talk about the extent to which businesses and consumers really need wrap contracts to exist. I think there's an assumption in a lot of the case law and the commentary that common transactions would just go away. They just would not be possible if it weren't for the oodles and oodles of boilerplate terms that we find in these wrap contracts. I think it's sometimes an explicit assumption. I think when it's not, it's almost always an implicit assumption. And the problem is that once we sort of assume that we have to have these terms in the transaction somehow, the law then feels okay about bending over backwards to figure out a way to sort of legitimize them. And so we don't scrutinize assent as much as we would scrutinize assent. We don't make the unconscionability doctrine particularly robust because we're worried that it will essentially undo transactions, and we won't have car rentals and mortgage agreements, and we won't have software purchases and so forth. So a couple examples of this being made as an explicit statement, Hill versus Gateway, one of everyone's favorite wrap contract cases. Judge Easterbrook basically envisions two possible worlds. So the worlds in which there's wrap contracts that just sort of automatically become part of the deal, even if they arrive later and the consumer never sees them. And he says the only other thing we could possibly do to have a functional universe is for the staff at the other end of the phone to read it at the front end, in a droning voice that wouldn't do anyone any good. To take an example from the Academy, Eric Posner says contracts are long and detailed by necessity, right? This has to be the world. To sell goods, manufacturers need to be able to put just the crucial terms up front and then sort of put all the other much more lengthy contractual language on the back end. And to summarize Nancy's book in 2 words, this is sort of, I think, her response to them. So my argument here, I guess, is that we shouldn't. This is going YouTube, right? Yeah, she really said this for all you defamation lawyers in Chicago. So my argument is that we should actually challenge these assumptions, that it's actually useful to think about whether we could exist, whether the transactions could actually go forward in a world that doesn't have the boilerplate wrap contracts. Because if it's true that we don't need this language and that contracts aren't long and detailed by necessity and those transactions could still go forward in a satisfactory way without it, well then the law can stop bending over backwards to find excuses to include the language, which is what I think cases like Hill and Proceed do. Now, how to get rid of them is not my focus, right? The particular doctrinal levers we pull to be more scrutinizing of wrap contracts and make sure that there's true assent. Nancy offers up so many good ways to do that. I don't need to retread that ground. I think there's good tools available. But I want to talk about sort of the consequence. Would the transactions be able to happen if we were successful in getting rid of that sort of thing? And to understand why I think transactions could actually take place even if we didn't have all these terms, consider that the crucial terms of a contract are almost never in the boilerplate, right? They're never buried in the wrap contracts. They never arrive afterwards. They're there up front. The article that Leonora mentioned was a study where I bought a lot of computers and tracked the contracts that I became bound to as the purchaser of a computer and when I became bound to them. And the terms I really cared about as a purchaser of a computer were never in the boilerplate. They were never buried in the wrap contract. They were always presented up front. So here's a screenshot from one of the computers I bought was a Dell. And you can see a lot of the important consumer terms right up here on the screen. There's we know what the item is, the Inspiron 580. We know the quantity, 1. We know the price, right? We know the delivery terms. All of this stuff, before I actually hit the place order button, is there. And not only is it there, but with regard to many of these features, it wasn't actually an adhesion contract. The seller of the computer offered me a lot of options. Do you want it delivered quickly? Do you pay a little more? Deliver later, pay a little less. Do you want the extra room on the hard drive? Do you want the extended warranty, right? Do you want the in-home service plan? And so, up until this point, the transaction doesn't resemble the problematic wrap contracts issue that we're all so worried about. So at least from my end, it could easily proceed if this was it, and there were never any more contracts in the mix at all. So the question, I guess, is could the transaction proceed from the seller's end if this was all the only terminology we had? I think it's hard to imagine that the absence of further terms would be a real deal breaker or would actually materially change the price that I'm paying. After all, there's this wonderful world of default rules ready to fill in the blanks that are left by the fact that this is, I think, a definite contract, but certainly a very incomplete contract. Coming from the world of intellectual property, I'm well aware that we try really, really hard to get these default rules right. So if you don't alter, the right to reverse engineer or the right to make a copy and install it on your computer, we hope that we figured out sort of what the right outcome should be in the absence of these of contracting around those background rules. For example, a lot of the contracts I found in my study were end-user license agreements for software. Well, if we didn't have them because they weren't up front, so suppose that through whatever legal mechanism we decide that those don't actually apply, they're not enforceable. Well, what would that look like? Well, I still get a copy of the software. I'm the owner of a copy of the software. And the Copyright Act, conveniently in Section 117, gives me a right to sort of install and use that copy of the software in the way that it was intended. So sort of like a single-seat license, which would be all I would need. If I wanted something more than that, if I wanted sort of a multi-seat license for an enterprise, obviously I'd have to negotiate separately with the software owner, but for the usual purpose, the transaction wouldn't explode, and the license would be about as narrow as the license that I would get in the later arriving wrap contract. Or the ever-present arbitration clause. What would happen if the arbitration clause weren't part of it? Well, you'd have to go to court if you had a problem, which, frankly, I don't know if that's any more attractive to the consumer than arbitration is under the AAA rules. And, of course, if the parties wanted to arbitrate, they would be free to arbitrate when the dispute arose rather than being obligated to arbitrate under the wrap contract. The most interesting part of the boilerplate to me that would be missing if this was the sum total of the transaction is actually the part that Nancy calls the instructive contract terms, which are the terms that actually don't take anything away from the consumer but actually impose obligations on the seller that wouldn't be there absent the contract. So I'm talking about maybe privacy policies by which the seller agrees to maybe be more protective of privacy rights than the background law would require, warranties that might go beyond implied warranties, return policies, right, which, as far as I know, if you don't have a return policy, you pretty much don't have to take returns. I think the default law would essentially, unless there's a product defect or something, say caveat emptor. As Nancy explains so well, these instructive contract terms are really there just to sort of communicate policies of the seller to the consumer, because they, at most, restrict the seller rather than imposing obligations on the consumer. And so if all you want to do through your boilerplate is just talk to the consumer and say, here's my return policy, here's my warranty, you can just put that on the website, right? It doesn't have to be in boilerplate. It doesn't have to actually be contractual. It can just be sort of something you put up for informational purposes. So this is not to say, of course, that people shouldn't be free to contract around the background default rules, right? I'm a believer in the free market. I believe that you should be able to arrange your own affairs against this backdrop of background law. But I think this is exactly where the case law regarding boilerplate has gotten it exactly backwards. Because boilerplate is seen as inevitable, something we have to have in these transactions, the law is willing to live with all of these indications that we're not really contracting around them, right? That there isn't actual expression of personal preferences against the background of default law. Things like, well, we all know, we could probably all say it together in chorus, right? An absence of assent, the inaccessibility of the contracts, the fact that they arrive later, the usual parade of horribles that we talk about. There's more I could say, particularly about if this is true, and we are actually more demanding of proof of assent or whatever other lever we want to pull in getting rid of boilerplate. If that's true, we actually have to think more deeply, I think, about what the default rule should be, because they'll be playing a more active role. But I want to give Nancy time to talk, and so I think I'll probably just end it there, just with the notion that contracts, boilerplate and wrap contracts are not inevitable, they are evitable. So there you go.
Member of its executive committee of the Commercial and
thank you thank you, Leonora, for the very nice introduction. It's my great pleasure to be here today. I wanted to thank Jennifer for organizing this wonderful conference and St. Thomas University for hosting it. This has really been, a terrific conference, and like Dan, this is one of my can't miss conferences of the year, the only one really that's a can't miss for me. And so it's really a great honor to be here, and I'm really honored that the panelists, these great scholars in this area, have deigned to talk about my book. It's a great pleasure for me, and like Wayne, I have a fear that nobody has read it, but it became clear to me that at least the panelists have read it, so I was very happy about that. I think that they've done a better job than I could have at summarizing, explaining what my book is about, because I've been working on this project for so long that when I try to talk about it, I get too jumbled up in various sort of thoughts. And so thank you very much, because it makes my job a lot easier, my response. So I wanted to talk, first of all, I wanted to respond to a couple of comments, or maybe try to clarify the shield, sword, and crook provisions, and that this also what Dan talked about, and which ties into what Wayne was referring to as well about notice, and is consent always necessary. And my position is that there are some terms that don't actually require assent, and those are the shield provisions. Those are the terms that just sort of outline the scope of a license, for example. You don't need somebody to consent. So taking it back to the property context, I don't need your consent to tell you I want you to, let's say, take off your shoes before you come inside my house. You can either not come in or come in, but it's my prerogative because I own the house. Okay, so that's just sort of an analogy. But that analogy and sort of your rights as and I refer to them as proprietorship rights as opposed to property, because property has other issues, as Jim knows from the IP world, that there's some issues with intangibles being sort of called property, the way real property or tangible property might be. And so shield provisions are those which protect the proprietor's rights, and they have a right to impose those whether or not the consumer consents. And I put warranty disclaimers up there only because the UCC permits warranty disclaimers provided they make certain conspicuousness requirements. Otherwise, they would fall under a shield provision. But because most states have adopted those provisions, as long as they meet certain conspicuousness requirements, then that's pretty much all we need. The shield provisions are the sort of instructive contract terms. Okay, so they basically just are there to inform you and to protect certain proprietorship rights, to draw the line so you know as a consumer what you can and can't do, something which you would not otherwise be able to do by law. The shield provisions, on the other hand, take away rights that you would have, and so they need specific assent. At least that's the argument I'm making. That. Oh, sorry. So I'm sorry. Thank you. I'm glad somebody's paying attention. Just testing, see if you're all awake back there. So the sword provisions are sort of destroy the consumer's rights, and because it requires the consumer to give up something, give up a right, they require contract, which means that they require the consumer's consent. Crook provisions are the same. They also require specific assent, but they're sneakier. And so the reason I sort of call them out separately is because we have this body of case law already dealing with sword and shield provisions. And the crook provisions are those that they require specific assent, but are also up for unconscionability analysis. So you can kind of go at them on the back end. Okay, so it doesn't kill your contract formation, but you might still be able to kick them out under an unconscionability analysis. And that's why I've set up the three buckets, because I think you would need to assent to both the sword as well as the crook provisions, but the crook provisions are also due for a little extra scrutiny, okay, because they are not part of the transaction. So the shield provisions, as long as they fall into the same category as implied contracts. So which is how courts are analyzing all wrap contracts. Basically, as if a reasonable person would have noticed the terms, and yet you proceed with whatever action it is, entering onto the website or opening up the package. If a reasonable person would have noticed that, and you go ahead, then you've agreed to the terms. Now, I think that's okay when we're talking about stored provisions, but not when we're talking about crook provisions. I think they require a little more affirmative action on the part of the consumer, because they're a lot more unexpected. Okay, so that's the reason I've set up those three different buckets. And I think what the courts have done, going to, now to what Jim referred to, do we really need all these provisions? Well, as far as the sort of individualized terms, yes, they're on the website, but and this is where I might lose some of my consumer rights friends here. I do think that businesses, yeah, they do need to assess the risk, and there are some types they need to structure. I used to work in house, yeah, they did negotiate. This was business to business, but they really did negotiate limitations of liability and warranty disclaimers and certain other provisions that would fall under sort of a shield, the shield category, and some sort, depending on the disclaimers and so forth. And so I think it would kill some businesses, and especially smaller startups. And those are exactly, the counter argument to whenever anyone raises any attempt to pull back on standard form contracts, the counter is it's going to kill business innovation, right? And I talk about that in my book. But I think that if we do take away the ability of businesses to actually bargain with consumers, it will actually cause damage. And so I'm really focused on improving the quality of the consent in a way that reflects the bargain. Okay, and I don't think that's been done for a variety of complicated ways in which the panelists explain much better than I'm able to right now, because as I said, I tend to get wrapped up in my own thoughts, but which I explain better in the book. But basically it's because with courts, it's an all or nothing deal. You've either assented to the to the contract or you haven't. And once you've, as Danny, I see, has written about this this idea of once you have established consent to a contract, it's hard to sort of get courts to evaluate terms, right? And so this is actually the problem. So once you've said, okay, we've assented to a contract, there is contract formation, the courts are really reluctant to evaluate terms. They don't want to reevaluate bargains, right? The courts will not evaluate the adequacy of consideration. We've heard that so many times. But yet we have these doctrines out there that actually permit that. But they just don't know what to do, where to go. And so that's the reason for the taxonomy, is to say, look, there are some terms that, yeah, they do maybe need to evaluate the risks, the costs and benefits of entering into a particular transaction, including limitations of liability. For some businesses, it is very important. For, I would say, all businesses. It affects their insurance policies and all that. Credit provisions, that's something else. And the problem with wrap contracts, unlike the paper contracts, although we're seeing now a little bit of online, offline problems here, where a paper contract will then reference their online agreement, which would then is hyperlinked to 10 different other agreements. That's really the problem, because that's when you start to get these really problematic crook provisions. So I do think that my proposals don't do away with the bargaining inadequacies that were discussed on yesterday's panel, but contract law can't do everything, but it can do a lot more than it has been doing. And the problem is really that, first of all, I think the judiciary has become a little enamored of the law and econ arguments, the efficiency arguments, without sort of taking into account how markets are affected by informational sort of inadequacies. And they also have not really considered how CRIC provisions have pushed norms or have shaped business norms. So, for example, we talked about Facebook and how, well, for Facebook, the bargain is your information. Even though the consumer might think that. They think they get this cool stuff and they know they get some they give up some of their privacy. But But let's think way back to 8 years ago, 9 years ago, when Facebook first made its sort of appearance. What they presented to the consumer wasn't, we're going to take all your privacy later. Okay, they said we are safer than MySpace, right? That was the pitch they had made. We're safer than MySpace. We are a safe community, and we keep your information secure and private. That was the pitch they made. Okay, and then they kept changing their terms, but nobody was paying attention until they were about to go public, and then EFF was all over them, right? And they actually have on their website this, how Facebook's terms of use have changed, and over the years, how it was first, yes, we protect your privacy, then later it's we're going to exploit the heck out of you, right? And as for whether where you've got the problem with the shifting norms is that now consumers are starting to be aware of these privacy problems, right? But they've got sunk costs now. They've got this entrenched network. They've got history. They've got where are they going to move? Where are they going to move all their content at this point? So you've got sunken switching costs. And so it's a little bit of a bait. It's not a little bit. It's a bait and switch. Okay, it's just in the online context. And so wrap contracts are even worse than paper contracts for that reason, because of the way the terms are constantly changing without signaling those changes to the consumer. And I know Juliet Marangella is here, and she's written the first, I think, article on signals and internet contracting and Assent. And I think that's even more true now. And I want to, I don't know how much time do I have? I want to go through some of the slides that I brought just to illustrate. Okay, so, all right, this is the gorilla study that highlights what the researchers refer to as inattentional blindness. So, as part of the study, participants were asked to count the number of passes that the black-shirted team made, or the number of passes the white-shirted team made. They had two different groups. And so they were supposed to count the number of passes they made. And so in the middle of counting this is a video clip. A woman in a gorilla suit walks up and stands in the middle and thumps her chest. Okay.
She counted as a black person? Black shirt?
Oh, well, the thing is no, because nobody noticed. So nobody noticed a woman in a gorilla suit standing up there and pounding her chest. Okay, so my question is, if you don't notice a woman in a gorilla suit in the middle of a basketball game, are you really going to notice a click when you do it, or are you going to really notice a browse or a hyperlink? And the problem is the courts are doing an ex post analysis. They say, would a reasonable consumer have seen the link, because they're actually looking for it, right? They're not looking at it before the transaction. They're not actually putting themselves in the consumer's position. Oops. Okay, so this is how Facebook, their homepage looks. Okay, so you can see what they want you to do. They want you to download some apps. They want you to sign up. There's a big green inviting button. But if you are to read their terms, first of all, you have to fill out all the forms, and then you sign up. So you have these sunk costs, right? You've already spent time inputting your information. And then you've got a problem here, because you either need to click on the terms or you need to click the sign up button. So which do you do? Well, you already filled out the terms. You don't want to refill them, because who knows, if you click on the terms, you might have to refill the form again. So most people are going to click sign up. If Facebook really wanted you to read the terms, they would put terms in the big sign up button, and they put sign up as a hyperlink, right? Or they would give you an option to sign up after you've clicked on the terms button. So this is not actually an attempt to get you to read the terms. It's an attempt to meet this very constructed definition of notice. Okay. This is an example of a very boring online agreement. Who's going to read this? Yeah, I feel like falling asleep right now just looking at it, right? Oops. The touchpad is. Okay, so the question is, how would a reasonable drafter present the contract? Consumers there's a presumption, Chuck Nevis said it's really a presumption, not a duty to read, but the courts, if you look at the cases, they sort of look at it as a duty to read, or that you're presumed to have read the terms if you signed or clicked. But there's no corresponding duty to draft reasonably on the part of the company. And why not? Especially since they have all the power. They have all the bargaining power, not just the bargaining power, but also the actual contracting power, the power to establish the form in which the contract is entered into. Okay. So, there's got to be a better way. I'm not doing something wrong. Okay. So I want to talk about a study. Students at a university were asked to answer some questions. And this is the format which the questions were presented. And when it was presented in this format, oh boy, you had a lot of pot smokers, you had a lot of cheaters, you had a lot of people who drove, who were over the legal blood alcohol limit and drove. Okay. But when the same questions were presented in this format, oh no, nobody did any of those things. Okay, so context really matters. The context, it's the same questions, it's just people felt differently. Okay, so context and presentation really affect consumer perception. And companies know that, which is why they engineer their websites in a particular way, and why they make the terms look so boring and unreadable. They don't want you to read them, okay? There was a study recently about how users, and I don't have the stats off the top of my head, but how if the agreement is textured, if you have cartoon bubbles, I don't know about you, but I will read anything in a cartoon bubble, okay? And if you have visual images and the danger mark, okay? If you have textured agreements, consumers are much more likely to read the terms because it's more interesting. There's more visual appeal. Same with nutrition labels, which is why this label on the right has, there was a study done, participants actually found reading this type of label actually entertaining, enjoyable, they said, shocking, right? And they were much more likely to read. So everyone talks about how consumers don't read terms. And that's true, because why would you? You saw that first slide I showed you, and some of you in the back fell asleep, right? And I almost did. But when you see cartoon bubbles, I don't know, I'm always, it just sort of sparks something, and you want to read what's in the bubble, or you want to read what's next to the big exclamation point, okay, because it's important. Okay, so let's go back to Facebook. If they really wanted you to read the terms, how might they present this? Now, I have to remind all of you, I know it's hard to believe, but I'm not a programmer, as you all, and I'm not particularly tech savvy. I mean, not compared to a lot of people. And so if I can make this more noticeable, the folks at Facebook could do a much better job. They also have the money to do usability, to do testing. I mean, they to do some market research to see whether or not consumers will actually read terms, but they don't. So what could they do? Well, this is my sort of feeble attempt to make the terms more noticeable. Okay, so if that popped up when you went onto the Facebook site, you would read it, and you would realize, wait a second, this gets the point across without having to click through 3 different documents and read through a bunch of fine print. And this does it for Facebook. It'll protect them adequately. Okay, this is all on the Facebook site. They don't really want you to read that, right? So let's force the consumer to read it. This is the specific assent requirement. Now you think, oh, this is awful. I don't want to click, 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 click. And that's exactly the point, okay? Because the fact is, if they're taking more from you, I want you to feel it, okay? I want you to realize that this website, Facebook, requires me to click 20 times because they're taking all this information and they're using it in this many more ways. Whereas maybe a different website, doesn't actually sell my private information. They just uses the content to display for the purposes of running their website. And so it makes the bargain much more transparent. Something else they could do is they could, after you sign up with the website, they can email you a little notice and require you to type your name, and it raises the signaling effect. Okay, so you actually have to then type your name and email it back to them, and then you would have consented as opposed to clicking. Indemnification, this is on Foursquare's website. You have to indemnify Foursquare, and I'm sure that's a pretty big obligation, right? That's not something that you would have agreed to necessarily, or maybe you would have, maybe you don't care. But this really drives the point home, okay? So it has the icon, the danger icon, and then you're required to click, okay, to specifically acknowledge that you've seen it. And you may even, you may even have to do one of those CAPTCHAs, you know, that make sure that you're, but the purpose is to make sure that you're not a bot, but in our case it would be to make sure that you actually understood, there are attempts to overcome consumer habituation to clicking. Okay, the fact that we do it all the time and we never it never really registers. So all of this making the assent more burdensome is a way to make the offering, the service offering, reflect the bargain entered into. It's an attempt to make transparent what the deal is, to avoid this, just sort of counter this bait and switch that companies tend to do with digital contracts. Okay, and this is another way that a company might break the cycle of clicking, of habituation. You know, you're so habituated doing it, it doesn't even register. So you've got the danger icon, and then you have to type your name. And again, it's in plain English, but it doesn't matter so much if it's in plain English if the consumers never get to that page. Okay, this is from the Pinterest website. And what they've done is they've explained in plain English what's going on the left. And I thought this was pretty good. This is a better attempt to make terms readable. So companies can do it. But what's interesting, right, so they'll say, you know, they'll have their sort of user policy, and they'll sort of explain what it means. Don't post porn or spam, okay, or Pam. Or be a jerk to other pinners. Okay, so it makes it very clear. We respect copyrights. You should too. It gets the point home, but then they have the more extensive legalese on the left. But what's interesting is when you get to their privacy policy, those little text boxes are missing. And why might that be? Do you think it's maybe because consumers are starting to care about what happens to their personal information? Okay, so I don't know, but I just found that kind of interesting. Okay, so a final point I want to make is that I have a number of different proposals in my book. And one that Wayne talks about is this idea of notice versus contract. There are some terms that require no consent, some terms that require notice and are really sort of implied contracts. And there are other terms that require much more active consent, and those would be the correct provisions. Okay, and what I refer to and I also refer to something as a sort of functionalist approach to contracts. Courts look at the reasonableness of terms within sort of the context of other words in the contract, but they should also look at the function of the contract in a transaction. And so if the contract's purpose is to establish codes of conduct, okay, it doesn't really require assent. Not everything needs assent. Although privacy policies, the reason they're there is, first of all, they're privacy stripping policies most of the time, and they're there because the law requires that privacy policies are posted, and so it is a notice requirement. And also because it's not really clear right now what the law is as far as the company's ability to use private personal information. And I refer to this as a legal no man's land, which is created by technology, because technology sort of advances and then the law follows behind. You know, legislatures follow even further behind often. And so so the case law kind of comes after the technology is developed, and then the courts have to figure out what to do. So into this sort of techno-legal gap, companies, because they're trying to minimize their risks, they try to protect themselves through private legislation, right? Through contract. And so if we don't put certain limits on what a contract is, then in the space between when the technology is developed and when the cases decide the issue, or when the legislatures finally react, which they still haven't done with consumer privacy, norms become established and they become entrenched. And when those norms become entrenched, they affect the reasonableness analysis. Because when we go then to unconscionability, well, is it reasonable? Or, it depends on what other businesses are doing. Well, because the courts have been slow to respond, and because we view anything you click to as a contract, and those terms were in the contract, well, we're okay with consent, right? And so this is the problem. It's that wrap contracts are shaping business norms because, businesses have, why not? Nobody reads them anyhow. We might as well stuff everything we can into them. And so that's really the concern in this online space, and why I think it is qualitatively, not just quantitatively. Yeah, you click all the time, but at a certain point, it becomes a qualitative difference. The fact that there's so many more terms in online agreements, and so it really has a qualitative difference in terms of shaping the online landscape, the online marketplace. It has an effect as far as developing marketplace norms and business norms. And I think that is really the concern here. Okay, so I think I have, oops, I don't know what I've done here. Okay, so when I talk, I didn't mean to do that. When I talk about terms, a lot of times you'll hear, you don't need to agree to all terms. And so, for example, this contract, you don't really need to agree to this. This is an instructive. It's what you can do. It's what you can't do. This is an example of a shield provision. Okay, and if you don't read it, too bad. If you do something that the company doesn't want you to do, it's their prerogative to kick you off their site. That's what they can do within their proprietorship rights. On the other hand, companies might take advantage, exploit the contracting form, the fact that courts have approved a click as indicative, as a manifestation of assent, to sneak in other terms that the consumer would really have a problem with, like this provision. This is from a website called Accessory Town. And because I thought it was such a great example of all the bad stuff we're worried about, I made it bigger. I blew up the screen so you could see what it says. And I think this actually beats the website, the ClearGear website, as far as onerousness terms. It says, every order is subject to all the terms and conditions stated on our website. There can be no cancellations for any reason once an order is submitted. Okay. If there's a failed delivery attempt due to an invalid or incomplete address, or failure of the customer to retrieve the parcel, or where the customer rejects delivery, the customer shall be liable for the full cost of shipping and handling plus a 20% restocking fee. Okay, so the 20% restocking fee would make a lot of consumers say, "What? I'm not buying from this website, right?" This effect, when people say, "Well, consumers they don't care," it wouldn't actually affect their decision to use the site. I think something like this would. Okay, and then the fun is only starting here, because there is an exclusive remedy that you have to go through their dispute resolution process, and then you've got mandatory arbitration, and then, just like in ClearGear, but even more attractive, or more consumer friendly, I'm just joking, is you agree not to file or initiate any complaint, chargeback, dispute, public comment, forum post, website post, social media post, or any claim related to any transaction with our website and or company. So just shh, we don't want to hear anything out of you. No, not a peep, okay? By using our website, making any purchase or conducting any transaction with us, I hope this didn't constitute a transaction when I visited their website to copy their terms of service. I know I'm on YouTube and everything. You agree to all terms and conditions stated herein. Okay. Now, any action in breach of this agreement that causes reversal, I'm sorry, I usually don't like to read off my PowerPoint slides, but this was just too good. Any action in breach of this agreement that causes reversal of any payment in full or in part any action in breach of this agreement, but it was so easy to breach it, right? It's so easy to breach this agreement. You agree, so it says, if any payment full or in part shall result in a collections action for the full or partial order total, the amount reversed plus an additional $50. Okay, so this is what you get for complaining. You got to pay $50. But in addition to that, you agree that any breach of this agreement shall also constitute liability in the amount of $200 plus any related costs, directly or indirectly relating for any such breach. So it sounds like a minimum of $250 if you open your mouth. It's hard to tell, though. It seems like it. So I think that for most consumers, they would run from the site. There's no reason to use this website, right? You can buy your stuff elsewhere. The problem is that most consumers aren't going to be aware of this provision until they're in the situation and they try to return an item or they post a complaint on a consumer review site and they get hammered with this. So anyhow, I think hopefully we'll have time for questions. And I didn't.
Yeah, let's get some questions here. I think we have a little, okay, definitely.
The gorilla story bothers me a little bit because I've heard it about 100 times, and I've never heard it in anything more than anecdotal form. I've never heard that it was verified or replicated by any other experiment. The gorilla photo bothers me even more because we're criticizing people who present boilerplate as hidden persuaders, basically. And I'm pretty sure that that photo is not a photo of the actual experiment, which in the version I heard had a woman walking behind the people who were throwing the ball, so that they would have to turn away from what they were focusing on to see her. They might have seen her in the background and ignored her, but I'm pretty sure it wasn't an experiment with someone in a gorilla suit standing in the middle of 6 people.
Actually, I saw the actual experiment at a museum, and it's a videotape, so that's a still from the videotape. So she walked through and she stood and she pounded her chest and she walked out. So, and it is a study that I think they've replicated. That's why sometimes it was black shirted, sometimes it was white shirted, number of passes. So that was not something I made. It was from the researchers, and they actually just wrote a book called, I forget the title of it, but where they talk about this, Dan Simons. And that's exactly right. That's exactly the point, is people are more oblivious. Exactly.
So I think this is fascinating. The question I had, the issue I have is this. So I write in the arbitration area, as you know. And so let's say Facebook had an arbitration clause, and they had all the warnings that you are suggesting, right? Danger, poison, skull and bones, kind of thing. And actually, you could even change it so that consumers can be led to pay less for a certain service if they agree to arbitration. So then you have the consideration specific to that clause, which again is more evidence of consent. And so the two questions I have are: A, would that really diminish or reduce Facebook's consumer base? But secondly, would it also not have the unintended effect then of making it harder to argue unconscionability? Like then you have this onerous arbitration clause that the consumer actually just clicked through it anyway, and then the court said, well, you actually agreed to pay less for this clause, or you actually encountered 5 different screens beforehand. So I wonder if that actually might backfire on.
That's interesting, because that's also the same question that Dan Barnhizer raised in his presentation yesterday. And when you were talking about it, I thought, I think that's theoretically right, but I think in practice it's not the case, because first of all, when we're talking about arbitration, okay, the case law there, as you know, is it's not that. In some cases, or it used to be the case that unconscionability invalidated arbitration clauses. Not so much anymore, because it's still kind of murky, right? It's sort of a mess in that area, as you know. And so I'm not sure if it would actually change things so much. And when we're talking about arbitration, well, for some businesses, it is actually something they want to bargain for. And so if it's something we just don't want to allow any company to bargain for, then it gets to the issue of who decides. And is that something that's appropriate for the legislature or for courts? And my focus is really on the fact that there really isn't consent at this point, and on improving the quality of consent. But if there actually is something that's bargained for, if I'm starting a business and I want arbitration because I really don't have the funds to deal with a lawsuit, or I don't want the publicity, or for whatever reason, and I want to bargain for that, then under contract law, I should perhaps have the right. But if we as a society don't think I should have the right, then is the more appropriate place for that the legislature? Okay, and I see Pete Linzer is like, okay. All right.
You used the word bargain so many times.
Yeah.
How do you bargain with a consumer in a form contract? There's no bargaining involved. You're using that word.
Mm-hmm.
I'm not talking about business-to-business pre-dispute arbitration. I have no problem with that. It's very useful in international transnational transactions. That's fine. But we're not talking about bargain here. And another thing is, you used other terms saying they're not contract, assuming that the dominant party owns something. It's a property question. That's the thing that got debated for 10 years over UCDA, whether software companies were selling software or licensing it. It's a big fight that went on.
Right, no, I understand that.
These are very important.
Right, I understand that. But I do think that if you're a business, you can't say that they don't own the rights to their intellectual property if they created software and they spent millions of dollars developing it. Well, okay, so that's a different, that's a different argument. But I think the case law establishes that there are certain rights you have as a business to establish the scope of the license, for example.
But that's
Okay.
assuming it's a license, and that's controversial. That's a matter of controversy, whether it's a license or a sale.
Well, I think it's a sale of a licensed product is what it is. Yeah.
It's what?
It's a sale of a licensed product. That's what it
Makes
is.
Subject to Article 2 in that case.
Right, right.
Which is a sale of goods.
And Article 2 does allow you to contract out of the default rules of the UCC.
I understand that.
Okay. All right. Danny, did you have a question or? Yeah. Okay.
One more comment, because there's another group that has to come in here, but did Dan want to add something, or John?
I'll ask Nancy later.
You know what, we can also, okay, we'll take one more question.
Okay. Just one more. I know I've discussed this with you before, Nancy, although I think, I finally had a revelation about this, because listening to Wayne's talk and hearing, people don't really know they're entering into contracts, made me think about yesterday's panel on teaching, on digital natives. And, we say, oh, our students are so different because, they're so used to contracting online. And I always wondered why people said, well, because I did say the signals were different almost 10 years ago, and I wonder now whether that's still the case. But the last bit, Nancy, when you showed the graphics, made me realize that maybe it's not the act of click that is not the act of a signature, but 24-year-olds don't react to that. The same way that they don't answer our emails because they're used to texts and
Right.
tweets, which is how I would not.
We're the LOL generation.
Right, and I think that's it. It's not that they don't know that a click is a contract, it's that they don't read that because that's not the way they're wired.
Anyway, nobody's wired that way, though, really, when you think about it.